Hello everyone. So I'm back once again with a suggestive list of answers for paper 2 of year 2023 patent agent examination that just took place yesterday, 7th May 2023. And the list of, so I'm just going to provide you the content that should have been, written as a part of your answer in your own words. And so by no way I'm giving you any format of the answers. If you wish to check for the real right format, how you should have written, then you can refer to my book or other free videos that I've uploaded on YouTube channel. And to the students of my class, I have already told them the format, but this video is just to tell you what should have been the right answers per question, okay? So let us go through paper uh, 2, part A. And just to let you know before we proceed with this, that I've already uploaded the video as for paper 1, all the answers, which you can check so that you know how you fared in paper 1 as well. So now with this, let us just get started with part A. 5 marks each is the question here, question marking. So question number 1 is state the factors that need to be considered for deciding the date of filing of request for examination after filing of an application for patent. Just let me do a quick check on YouTube if it is recording well. Okay, seems going good. So this question is not about date of filing of the request for examination. This is about the factors that need to be considered before one makes, suggestion or files for the request for examination. What are the factors that are considered? So you need to consider section 11B and rule 24B. And there are broadly 3 factors that you will consider. The first factor that one has to consider is what is the type of application, whether it's a convention application, a patent of addition, divisional, or a PCT. Because for each of these patent applications, there is a different date which describes or which is being prescribed in these particular sections and rules as to when a request can be filed. For example, it's 48 months for ordinary application from the earliest filing. But if you look at the divisional or patent of addition, it's a different date for date of filing of application. For secrecy directions, if these are imposed on any application, then it's 48 months from the priority patent application or date of filing, or within 6 months, whichever date is later. So basically, it's the type of application which is one of the factors that you consider for deciding the date of filing for making the request for examination. What is another factor that comes to my mind is the post dating, whether any post dating has happened or not. Did the applicant file for any post dating under section 9(4) or section 17 and or both section? So then in that case, the date of filing of the examination request would be from the new post-dated date and not from the original date. So this is one of the factors for consideration. And then you can describe these 2 sections in just in a bit in your own words. Another factor is whether there were any secrecy directions imposed on the application or not. If yes, then one should wait until the time directions are revoked. So these are broadly 3 factors at minimum you should put. There could be other factors as well, but these are uh, the topmost ones that must be presented and as the answer. So these are just the bullet formats, but final answer should be in a proper format, like I already mentioned. But this content you can write to describe that answer in 1 page or 1.5 page. Question number 2 is Raju is a creative person who is engaged in business of printing, wherein he mixed the paints with some fluorescent chemicals in a particular ratio, which led to this thing that amalgamated painting material, while it is being used, it appears visible during the night, even without any kind of light source. He has applied for a patent for amalgamated painting material and has also sought copyright protection for painting he made using the material. In both the applications, he did not disclose the composition of amalgamated painting material. What will be the effect of such a non-disclosure on protection of IP rights? So just to mention that don't try to read the questions. I'm therefore narrating it for your ease for all of you because these are a little blurred. So just hear through me. So like you know, and I've taught in the patent agent classes also to all my students, you have to make sure that you comply with Section 10(4) of the Patent Act, which means complete disclosure in the patent application is important. If there is non-disclosure, then there is a problem. So what are the problems? So the relevant sections are Section 10(4) and 25(1), which you can describe in a bit detail in your own words, where you can mention that there is a mandate to fully well describe the invention and also mention the best mode of performing the invention in the patent application. And if in case there is a failure to do so, if there is a non-disclosure, then the controller may not grant the patent in case he finds it during his examination that there are no disclosures given. The pre-grant opposition may also be filed under Section 25(1)(g) by any person to oppose to the grant of the patent. And the patent, if granted at all, may further be opposed under Section 25(2)(g) by a person interested, or may be revoked under Section 64(h). The rights of the patentee in case of non-disclosure may be affected, and the patent application may therefore not proceed to the grant, or if granted, may be later opposed or revoked. So this is what these are 4 broad content items that you can elaborate in few lines to describe your answer. Question 3 is about Karan, who is an Indian citizen. He owns a shipping company in Visakhapatnam. He got a call from his friend John, who is a US citizen and also owns a shipping company registered in USA. So again, I'm requesting you, don't please read the question, just listen through me because the question is very blurred here. So what happened is John, a US citizen, also owns a shipping company registered in US, informing that John's ship Discovery developed some technical snag while passing through Indian coast and needed some urgent repairs. He requested Karan to get it repaired in his dock in Visakhapatnam. On inspection of the ship, Karan realized that technical snag can be repaired using technology that is patented by Shiprep, an Indian company. The Shiprep's patented technology can repair such damages in few hours, as compared to conventional process of repair, which takes few weeks. Karan used that technology to repair Discovery at the Indian coast without permission of Shiprep. After few months, one of the ships owned by Karan also developed some problem, and Karan got it repaired using the same patented technology of Shiprep without permission. Shiprep came to know about it and for the use of such patented invention technology by Karan and approaches you for further guidance and expert advice. What is our guidance to Shiprep? Just 1 second. Okay. So as a possible answer to this is could be this Section 3. Use of Shiprep's technology that has been patented in India by Karan without the permission of Shiprep is definitely a case of infringement. Shiprep may send a notice to Karan for payment of damages. Further, the letter may ask Karan to be cautious in future not to use the invention without the knowledge of Shiprep and pay remuneration or royalties. Alternatively, or even simultaneously, I would say, a legal suit of infringement may be filed at the court not lower than the district court under Section 104 of the Patents Act. And you can define these 3 content pieces in a little bit more detail. You could also present something on, Section 49 of the Patents Act, which is about what is not infringed, what are the things which are, or what are the actions which are not considered to be an infringement. For example, if there is a ship or a vessel which is just in transit and it stops for a moment in a country where there is a patent and there is a use of the patented invention, then it's not an infringement, during transit, which is the case with the person who is the friend of Karan, that is John, US citizen. His ship is not going to stay in India, right? And the use of patented invention that has just happened in transit. So that briefly you can mention, but broadly, it's a matter of infringement as far as Karan is concerned, and he has been continuously using the invention, and he needs to be stopped for any such further actions. So this is the content that you could, that was to be provided as an answer. So this is a suggestive content. Now, question 4, explain about the Startups India Protection Scheme, which is SIP scheme, and role of IP facilitators, and compare the benefits offered under the scheme in both the years, 2020 and 2023. So there are three questions broadly embedded in question number 4. One is you need to tell about SIP scheme. Second, you need to describe role of IP facilitators. And third is compare the benefits between 2022 and 2023 scheme. So 3 items. So first about SIP scheme, you just mentioned about that it is about facilitation of patent and trademark and design applications for innovative works that are done by startups in India. Not only in India, but also for filing and protection in other parts of the world. Then Indian startups which are registered with DPIT, they can seek also expedited examination in Form 28 and Rule 24C can be then referred. So these two things, broadly about the SIP scheme, that it is a facilitation scheme in which there are several patent facilitators that are hired also to support such filings by Indian startups in India and abroad. So IP facilitators support and assist the startups free of cost because they don't charge it from startups. They charge it from Government of India for their time and effort, and enable the patent filings of Indian startups. They do complete handholding, including drafting of patent applications and prosecution at the patent office. TISCs have also been recognized as patent facilitators like BIRAC, TIFAC, NRDC, PIC, etc. Now, the third or the second portion or the next portion, about, so there were 3 pointers. One is about SIP scheme, then about IP facilitators, and third was about comparison of the benefits of the scheme. So there are 2 broad changes that have happened between 2020 and 2023 scheme. What are the changes? One is a change in the fee structure. So fee structure for patent facilitators changed in 2023. The facilitation charge has been increased from 10,000 to 15,000 rupee, which was lesser in 2020 scheme. Also, there is another change in the fee itself, which is at the time of disposal of application. They'll be paid 25,000 instead of 10,000 if there was no opposition. And if there was an opposition, then instead of 15, they now get 35,000. So it's a good incentive for IP facilitators to work for Indian startups now. Another change that has happened in 2023 scheme is that the functions and duties of patent facilitators have been enhanced. For example, they can now assist the startups with international filings as well, besides India, at International Bureau as a receiving office, or India, which is elected as a international searching authority. So this is quite a lot of content that you could have, you could mention as the answer to question 4 in your own words. Now, this is just the additional thing I just wanted to present, which is year 2022, and these are the timelines. These are the fee structure. In 2023, the fee structure changed, which is what I just explained you. So you can stop the video here if you want to do a comparison of the fee, one for 2020 and then other for 2023. Okay, so now we proceed to part B, which was of 10 marks each. Question number 5, what would be the reasons for advising your client to file a request for early publication? And what are the advantages of waiting till 18 months for publication? Discuss citing the appropriate provisions under the Patent Act. So there are 2 questions within this question number 5. One is, when will you advise your client to file for early examination? And when will you say that, okay, no, you wait for 18 months? So what are the benefits for waiting? So early publication is requested primarily because it is beneficial as there is an expedited then examination request that also you can file after having it published early. Early publication allows for quicker, let's say, prosecution of your patent application. And early, therefore, disposal of patent application enables the applicant to identify appropriate market strategy for early launch of the product as well. So there are quite a lot of benefits, just that one has to pay an additional fee of rupees 2,500 as far as Indian startups, natural persons are concerned, and 12,500 for others category. Now, the second portion of the question was, what are the advantages of waiting for automatic publication that happens after 18 months? So if one waits for 18 months and doesn't hurry up, then certainly applicant doesn't have to bear any additional cost. Because there'll be an automatic publication by the patent office anyway. And the applicant gets enough time to further work his or her invention and make up his mind whether to continue his application or withdraw it, before it gets even published and re-identify his strategy, whether to refile again with a lot more content and experimental data, etc. So, so these are the things that you could write as possible answers, not in the form of bullets, of course, but in your own words. Another question, PS Polymer Limited designed an attractive paper cup with corrugated design and got the design registered in India. An inventor, Raghu, made a patent application for a corrugated paper cup, which includes a cup body, a cup bottom, a cup sleeve having horizontally and vertically corrugated stripes, on which there are many grooves, which provides a grip to the user of the set cup. Designer team of PS Polymer finds his application in the Patent Office Journal, and while checking the drawings of the patent application, the designer team found that the claimed cup in the patent application is substantially similar to the corrugated design registered in the name of PS Polymer Limited. Now, during the search on the above said application by PS Polymer, they also found one patent document, which is IN 123456, where corrugated shape of different pattern was patented, which appears to be for the same purpose. Further, they also found that Raghu had not explained the process of making the cup in the description. So PS Polymer Limited approaches you to file representation against the grant of the patent to Raghu. Prepare a representation under the provisions of the Act and the rules. So there are two things that are there. One is Raghu has filed for similar invention that PS Polymer has already got design registered for. And second is there is another patent document for the corrugated design, a little different design, but the purpose is same. So what has happened is that Raghu has patent application, but in the patent application, he has not even disclosed the content fully well. So there is a non-disclosure issue as well. So let us just look at the proposed answer. So Raghu's patent isn't yet granted; it's still in the application stage. So actions that may be taken, they can be taken at the level of patent office itself by him or by his patent agent on his behalf. It's basically PS Polymer who can file this pre-grant opposition against the patent application filed by Raghu. So these are the different grounds on which it can be filed. So pre-grant opposition may be filed on the ground of wrongful obtainment by Raghu under section 25(1)(a). But this wrongful obtainment would have to be proved by PS Polymer though. Similarly, another ground that can be used to oppose Raghu's invention is under section 25(1)(b). That is by anticipation through PS Polymer's design registration, saying that it is not novel work because there's already a design registration by PS Polymer. PS Polymer can also file a pre-grant opposition, another ground against the grant of the patent is on the basis of lack of inventive step. So for inventive step, there is mosaicing that has to happen. So more than one patent reference has to be taken and pulled together to find whether inventive step was there or not. So besides PS Polymer's registered design application or granted design, rather here, and with reference to IN 123456 granted patent, both the patents, so design registration and this patent can be highlighted in the pre-grant opposition representation to say that it lacks inventive step. Another ground on which it can be opposed is section 25(1)(g), which is on the ground of incomplete disclosure. So said representation may be filed on form 7A. So this is what I found that could be the best content for as a response to this question. And you could explain all the listed above sections in a bit more detail in your answer sheet. Another question, which I think probably the last question of this paper 2. Rama Shankar, a farmer whose farm is subject to periods of drought, has developed a new process of manufacturing solar power operated pumps that improves the water obtained from pump by 75%. There is no other technology in the market that gives the same results in terms of water flow. Further, Gopika, who is his daughter, she's an engineering student and she has developed a system comprising of logic controller with electronic modules to keep track of the water yield from any type of pumps used in the farm. This system could display the exact output of water from each pump. Ramashankar and his daughter together owns a agro startup company named Rago Solutions. They wish to protect their invention in India. Gopika attended NIPAM, the IP Awareness Program of Intellectual Property Office, where she came to know about expedited examination, advise them on how to protect the invention in India at the earliest. So it's a very fairly easy question, I would say. So answer would be broadly these sections and following rules and fee you can mention. So file a provisional, you will advise the client to file a provisional patent application or file complete specification directly. But if there is a provisional application filed, then file a complete specification within 12 months under section 9(1). Then file for an early publication request on Form 9, Rule 24A, Section 11A. And the fee for this Form 9 by a startup is much less, which is 2,500, as they're eligible for this reduced fee in the capacity of Indian DPIT registered startup. What else can be done is that they need to file Form 28 alongside. And Rule 2FA, 2FB, 2CA, Rule 24C, all of these rules and this form you can cite, because it's not only that you file early publication, you also have to supplement all these, this particular form that testifies them as, at least that informs the patent office of them being a startup. They can file the expedited examination of application under Section 11B, Rule 24C by filing Form 18A and fee of rupees 8,000. They can thereafter timely reply to the office actions within the stipulated time of 6 months under Rule 24B5. This time period may further be extended, if at all, by 3 months, but then, which is on Form 4, Rule 24B6. But you should not advise your applicant that you should, stay or wait for an additional 3 months, because it's a question of them seeking for early grant. So they must actually timely reply to the office action and get it granted within the 6 months timeline, which is also, Section 21, to put an application in the order of grant. So these are the relevant rules sections that should have been provided as the answer set in your own words, and I could explain them in more detail. So, okay, I think this was the last question and this was the answer. With this, I must thank once again to all of you for watching this. And like I already said, that I've already uploaded the video for paper 1, which has all the answers, and you may check how you've fared in paper 1 as well. Thank you so much, and don't please forget to subscribe, because this is how you get to know, see the notifications for upcoming videos, and also please share it widely with others so that others get benefited as well. Thank you so much. All the best.